We are also looking to do a mini series of webinars in the future, focusing on more topic specific questions. So if you have any questions or anything you'd like answering, let us know and we can get a date for that and let you know when we'll be covering it. Today's webinar is going to last around an hour, so we'll be finished hopefully just before 1. And if you have any questions throughout the webinar, feel free to pop them in the chat or raise your hand or just pop your mic on, and we'll try and answer them as we go along. Could we have the next slide, please? So today's webinar is going to be all about release. So we'll be covering what dismissal is, competition, confidentiality, and intellectual property, some thorny issues around removing directors, restrictive covenants, notice period, payment in lieu of notice, and garden leave, and then just some information about if you want to get in touch with us and contact us. Next slide, please, come on. So we're Burley Law. There's Liz, she's on screen, and she's our employment law solicitor. And then we have Des, who works in the commercial tech and IP side. Then we have myself, I'm Isha, I'm a paralegal. We have a trainee solicitor called Reese, and we have Hamon, who is doing ad tech for us today. She's just started with us. So we're a niche law firm. We specialize in intellectual property, commercial tech, and HR and employment. And our values are on the screen there: people first, collaborative, straightforward, and embracing challenging and change. Next slide, please, someone. So we just had a couple of questions to ask you first, just to see where your knowledge is at in terms of releasing staff. So if you want to pop your answers in the chat, or feel free to just say them out loud. First question is, which of these is not considered a potentially fair reason for dismissal in the UK? So is it A, membership of a trade union, B, poor job performance, C, pregnancy, or D, whistleblowing? Does anybody have any idea? B. Yes, B is a potentially fair reason. So capability is a fair reason for dismissal in the UK. So number 2, in the UK, employees are protected from unfair dismissal from the first day of their employment. Is that true or false? False. Yes, so generally it is false. Generally, people have to have 2 years plus of continuous employment, but there are a couple of circumstances where you can have automatic unfair dismissal. For example, for pregnancy or maternity leave, if someone's asking for their legal rights, or if they're taking action as part of a trade union, or for a health and safety reason, that would be an unfair dismissal from day one. Number 3, what is the maximum compensatory award for an unfair dismissal claim in the UK? Is it A, £25,000, B, £50,000, C, 52 weeks gross salary, or D, there is no limit? Oh, George just answered the question. So it's C, 52 weeks gross salary, or a maximum of £105,707. So whichever is lower of the two. And then the last question is, which of these is not a dismissal in legal terms? A, mutually agreed termination, B, redundancy, C, employer giving notice, D, payment in lieu of notice, or E, garden leave. Does anybody have E and C? So A, mutually agreed termination, D, pylon, and E, gardening are not dismissals. A, because it's mutually agreed, so it's not the employer dismissing the employee. And then D and E, they are around how notice is given when dismissing an employee. So we'll be dealing with all of this throughout the webinar, but those are just some questions to get us started. So I'll hand over to Liz now. Next slide, please, someone.
Hi, everybody. So we're going to start with thinking about D is for dismissal. Now, just before I get into that, employment relationships are based on contract. The law of contract in the UK is generally based on common law. Parties have freedom of contract, and they are free to agree whatever terms are necessary to make that relationship work. Now, the law on employment contracts is slightly different in that, yes, there is some common law involved where parties, employer and employee, can agree what goes into the contract, but it is overlaid by statutory rights. So legislation which governs, puts limits on what employers can and can't do to employers, because it's recognised in the UK and in a lot of other jurisdictions that employers and employees have unfair bargaining power. So the employer is more powerful basically than the employee. So that's why statutory rights are built in. But they sit alongside contractual rights. Sometimes they trump what is put into an employment contract, and we'll see some examples of that as we go through. So given that employment is basically a contractual relationship, either party can end that relationship on notice. And if there's a written contract of employment, it will usually deal with how much notice is to be given on either side to end employment. And so we see on the screen different ways that employment can end, different language around the ending of employment, which is essentially about this ending through notice. So the first one, by mutual agreement. Are we dealing with a dismissal or a resignation then? By the way, when we use the word giving notice, when it's done by the employer, that usually means a dismissal. So the terminology in statute on unfair dismissal and other areas of law uses the word dismissal. So where the employment relationship is terminated by the employer, that is a dismissal. When it's terminated by the employee, we usually call it a resignation. So on the screen, mutual agreement, sometimes this happens, employer and employee agree. It's, just part company, it might be a letter done in writing, perfectly acceptable. The law isn't going to say you can't do that. There would be no dismissal or resignation in those circumstances. But sometimes where employer thinks there's been a mutual agreement, employer says otherwise, they contest that and say, no, I've been sacked, I've been dismissed. An employment tribunal might decide, actually, there was no mutual agreement, there was a dismissal. So you need to be careful if you're going to enter into a mutual agreement. It's very clear that both sides agree to that. Voluntary resignation is what it says. It's not a dismissal. It's the employee voluntarily leaving their employment on notice. And then termination by the employer, as I've said, can be either on notice or without notice. We'll come to circumstances where it can be done lawfully without notice. That would be a dismissal. Resignation without notice in response to something the employer has done is usually called constructive dismissal. And there's a whole section of law that's very specific on constructive dismissal that we'll touch on a bit later. And then the expiry of a fixed term, sometimes people don't really understand this, but it is actually a dismissal in law. When a fixed term employment comes to an end, that's not a mutual agreement. It's not the employee deciding to go. It is actually a dismissal in law. It's a termination by the employer. So things that we need to be very wary of when we're talking about dismissal and unfair dismissal. If an employee has less than 2 years continuous employment, so without breaks, then there are no rights, what I call vanilla rights, ordinary rights to claim unfair dismissal. The unfair dismissal right only kicks in when you tip over 2 years of continuous employment. Now, the thing to be wary of is under 2 years, There are statutory rights which apply to all employees and workers around discrimination, whistleblowing, and some automatically unfair reasons for dismissing. Isha touched on them in the little quiz that we did. So automatically unfair reasons could apply where there's the health and safety is at play, or where there is whistleblowing, or where there are trade union reasons for somebody being dismissed. Now, the language that sometimes employers use to dismiss people can be very loose, and they can think that they are not dismissing in law, in legal terms, because they're using different language. Terms like making redundant, letting someone go, often used for, well-meaningly, but to try and get around any suggestion that it's the employer dismissing, and therefore there's no suggestion of unfair dismissal. And we'll come on to see in a moment that these terms are not ways of getting out of the unfair dismissal law. So notice, just to touch on this, and we will come back to it. Notice can be statutory or contractual. There is a statutory minimum amount of notice that must be given by the employer and by the employee. You cannot contract out of, you cannot agree something different in a contract of employment that is below statutory minimum. Very important. But you can agree more than statutory minimum. So the statutory minimum amounts of notice are where employment is below 1 month, no notice. But after 1 month, 1 week's notice by the employer must be given for employment up to 2 years. And then beyond 2 years, it's 1 week per year of employment, up to a maximum of 12 weeks. If you've got somebody that's employed beyond 12 years and they entitled to 12 weeks of notice. On the flip side, an employer must give no less than 1 week's notice to an employment, regardless of the length of service. So different on either side. Okay, we're going to go on to the next slide, please. So reasons for dismissal. So fair dismissal. We're talking about the law that kicks in when somebody has got over 2 years employment. And this is all set out in the Employment Rights Act. The law in the Employment Rights Act says that there are only 5 potentially fair reasons to justify a dismissal. And if you can't get into one of these boxes, then it will be an unfair dismissal. Now, what you label a dismissal as is up to you. But if it's challenged, then you have to be able to show to an employment tribunal that it is the genuine reason for somebody's dismissal. So we have 5 reasons. Conduct, we all kind of understand what that means, misconduct at work. Capability, and there we're talking about either the employee is unable to do their job or there is something stopping them from doing their job, maybe a health-related reason, they're off sick, for example. Redundancy, that's where the employee's role is being eliminated, or there are requirements for fewer of these types of employees within the workplace, and the employer has to decide who to make redundant. Statutory restriction, or sometimes we call that illegality, that refers to things that would make the employment a statutory reason why the employment cannot continue. So, for example, they may not have the right, they may lose the right to work in the UK. Every employee must have the right to work in the UK. Or it might be somebody who needs a driving licence to carry out their role, a lorry driver, for example, and they have a ban and lose their driving licence. That would make their employment illegal. And then the 5th reason is what we sometimes refer to as a catch-all box. It's called some other substantial reason. It's very woolly, it's very general. We don't really know what it means. And it's very tempting for employers to put a dismissal, this label on a dismissal where they can't fit it into one of the other boxes. But that isn't how it's to be used. Very often it can be justified to use this box for situations where there is what we call an irretrievable breakdown of the work relationship, where things have happened maybe over a period of time and they cannot be put right, and the trust and confidence in that relationship has gone, and there's no other reason why the employee is being dismissed other than this irretrievable breakdown. That's a very specific scenario in which you would use SOSR. Another example might be where the employer wants to change terms and conditions of employment, change the contract, and the employee refuses to accept the new terms. In that scenario, provided a fair process is used, an employer can potentially fairly dismiss for some of the substantial reason. But those are very specific scenarios. It's not to be used generally. So I'm going to move on to the next slide. So we know what the fair reasons are that we can hang our hat on for dismissing an employee, but that is not the whole picture. The Employment Rights Act says that you must have a fair reason, must be the genuine reason for dismissal, must be clear, and you must follow procedural fairness to dismiss that employee for that reason. The Employment Rights Act does not set out the exact steps you need to take to establish procedural fairness, but there is a code of practice which is helpful. And it's not only helpful, it has statutory effect, which means that you must follow these minimum standards in any dismissal situation over 2 years. If you don't, the Employment Tribunal, if they hear the claim of unfair dismissal, can take into account any failures to follow these basic steps and can decide that because they haven't been followed, the dismissal is unfair, even if you have a potentially fair reason. So it's very important to get the procedural side right before you decide to dismiss. So the code of practice link is on the screen. Isha, I'd be grateful if you could copy that and paste it into the chat. So it's a live link. You can find that code of practice on the ACAS website. I recommend that if you don't have a disciplinary policy in your workplace, you at least make reference to the ACAS code of practice if you are dealing with disciplinary matters, because that is the essential minimum standard. The code of practice applies to any disciplinary or grievance situation. That's not just dismissal, but it would apply to situations where other disciplinary sanctions are issued, like warnings or demotion. But it doesn't strictly apply on redundancy. So you don't have to follow this strict process on redundancy, although, as we'll come on to see, you do need to follow some kind of process for redundancies. So just to recap, what is required for fair dismissal for somebody with over 2 years employment? You need a fair reason from the list of 5, and you need to demonstrate procedural fairness. And what looks like procedural fairness, because it's not prescribed by law, will differ depending on the reason that you have for dismissal. So if we look over to the left-hand side of the screen, the ACAS code says that you need to act consistently. That means don't dismiss one person for this kind of misconduct, but when you haven't dismissed others. And there's a track record that you've acted inconsistently. So consistent treatment is important. Establishing the facts through investigation is important. So if you have an allegation of misconduct in the workplace, you need to investigate it to make sure that the facts are clear. And then you need to inform the employee of the basis of the problem, whether that's their misconduct or their performance or their absence. You need to give them an opportunity to put their case before you make a decision. So no suggestion of predetermined decisions before you have held a meeting with them. You've given them the information that they need to be able to put their case forward. And you must allow them to be accompanied at formal meetings. So not informal investigatory meetings, but formal disciplinary meetings or formal grievance meetings. And you must allow them to be able to appeal against a formal decision that's taken against them, whether that's a warning or dismissal. So those are the basic standards, but obviously what you do in reality in each of those stages will depend on the facts of the case before you. Next slide, please. So I mentioned redundancy a moment earlier. There is a guide or some guidance on the ACAS website, which, by the way, is brilliant and very useful for lots of different things. There's lots of advice on there, and there are some basic templates that you can use for various scenarios in employment. So when it comes to managing staff redundancies, the ACAS guidance says you need to have in mind some very basic steps, and a tribunal would want to know that these things have been done, and if they haven't, there's a good explanation why not. So checking redundancy is needed. What is the basis of the problem? Why are you even thinking about making a role redundant or selecting between different roles for redundancy? Is it reduced income, reduced revenue, costs, pressures? Is it the loss of a customer? Are you closing a site or a department? Are you pivoting the business? There has to be a sound or some kind of sound business case. Tribunal won't probe too much at that if you've got a business case. And next, you need to have a process, starting with telling the affected employees or employee that they're at risk of redundancy, holding consultation meetings with them, carrying out selection if you're having to choose who will be the person to be made redundant. You need to calculate redundancy pay, and you need to give notice of redundancy once you've decided who is going to be made redundant. You need to offer an appeals process and consider whether there's any suitable alternative employment that can be offered to the redundant employees. And support for your staff is very important because this is a very difficult time for them. So just a word on redundancy pay. I mentioned statutory rights earlier on. There is a statutory entitlement to redundancy pay that applies to any employee with over 2 years service. It's a formula that works out the sum they're entitled to based on their length of employment, how many years, complete years, and their age and their weekly pay. So it's very easy to do the calculation. There is a calculator on gov.uk, which you can find easily by Googling statutory redundancy pay. And notice we dealt with earlier, that will either be in their contract of employment. If they don't have a written contract, it will be the statutory minimum. Now, we've already looked at the notice period, so I'm not going to linger on that now. So can we move on to the next slide, please? Penalties for unfair dismissal. Sorry, go back a slide, please. Thank you. Penalties for unfair dismissal. So employees got over 2 years. You've sacked them, let them go. It is a dismissal. And they challenge their dismissal. They bring a claim in the employment tribunal. They have 3 months in which to make the claim by starting ACAS conciliation. And then once ACAS conciliation is finished, they must, within a certain period of time, file their claim on paper to the employment tribunal. The tribunal will, if the matter isn't settled, will eventually hold a hearing to decide whether the dismissal was fair or not. And if the tribunal decides that dismissal was unfair, either because there wasn't a fair reason or because the correct process wasn't in place, then they will make a finding of unfair dismissal. And then they'll go on to consider the amount of compensation to be awarded to the unfairly dismissed employee. So when we talk about penalties for unfair dismissal, they're not so much penalties against the employer. The employer isn't going to get fined for doing the wrong thing, but they are designed to compensate the employee for the unfair dismissal. So there are 2 elements to this compensation that can be awarded. The first element is a basic award, and that will be calculated according to a statutory formula. It's based on their length of service, their age, and their weekly pay. And then the second element to compensation is called the compensatory award. Now, the compensatory award is designed to compensate the employee for their loss of earnings as a result of the unfair dismissal. And the amount that will be awarded, remember we heard about the maximum 52 weeks pay or 106,000. That's the absolute maximum that can be awarded. It's not a blanket award. So the award that will be made will depend on the length of time the employee has been out of work and their efforts to find work. And if they have found work, how much they're being paid in their new job. And if their pay is more than the pay in the job they was dismissed from unfairly, then that will stop their loss of earnings claim at that point. But they can get awarded loss of earnings up to the point they start that new job. If the new job pays less than their old job, then they may be entitled to ongoing loss and claim the difference. Note at the bottom about breach of the ACAS code. The tribunal has the power to uplift the compensatory award and the basic award by up to 25% for breaches of the ACAS code. So those basic minimum standards are viewed as very, very important. And if there's not a good reason why they haven't been followed, then you could be in danger of that uplift on compensation, make it even a more costly outcome. Over to the right, a note on reinstatement. The tribunal does have power to order an employer to take back an employee they have unfairly dismissed, but obviously only if there's a finding of unfair dismissal. And if the employee requests this when they make their application to the tribunal must go on to consider it. And if they make an order for reinstatement, they would hear evidence to understand if that's practicable from the employer's point of view. But if they decide that it is, and they make the order that the employer must take the employee back, and that does not happen, then there is a power to award further compensation to the employee to reflect the fact that the employer has failed to follow that order. And the employee can either be given their old job back if it's still available, or they could be re-employed in a different role. So next slide, please. I think Isha's going to cover this one.
Thank you. Yes, so moving on to competition, confidentiality and intellectual property. In terms of competition, this is mainly around restrictive covenants. So restrictive covenants are a restriction that you can put in place which restricts an employee's activity after they've left a job. So for example, there are non-compete restrictions which restrict who the employee can work for. So they can't work for a competitor or in a competitive role. There are non-solicit restrictive covenants, which mean that the employee can't solicit customers or key employees of the company or suppliers when they move to a new job. And another one is non-dealing. So this is when the employee cannot deal with key customers, suppliers, or contacts of the company after they've left. So restrictive covenants have to be proportionate to the employee's role. So for example, Liz's restrictive covenants would be very different to mine because she's worked for the company longer, she's more senior. So say if hers were 6 months, that would be disproportionate to my role because I'm more junior than her, and vice versa. Restrictive covenants are also quite hard to enforce, especially non-compete restrictive covenants, but they can act as a good deterrent for employees to, it's more likely employees are not going to breach them if they're in there because they can be quite serious. It's important to have the restrictive covenants set out in your employment contract so that the employee knows what their obligations are on termination and that they're also reminded of these when you're liaising with them about their termination, whether it's accepting their resignation or informing them of their dismissal. Confidentiality and company property. So it's important that if people are privy to confidential information whilst they are an employee at the company, that these obligations are extended to when they leave. So they can be extended for a certain amount of time, for example, 5 years, 10 years, or they can be indefinite so that confidential information isn't leaked after they've left. And if they also have copies of confidential information or they have a work laptop or their own laptop, it's important that any company information is deleted or destroyed from there. So there are no copies remaining once they've left the company. And obviously, if there is any company property, that this is returned on or before the termination date. And intellectual property. So if you are an employee of a company, then any intellectual property you create is automatically owned by the company. But it's important if you are working with people who are external parties, so for example, a consultant or an intern, that you get an assignment for any intellectual property they've created because it's not automatically owned by the company. So if they leave and they start using it, it's not, you won't necessarily be able to sue them for infringement. And it's just important, again, like with the restrictive covenants, that people are reminded of these obligations when they leave. Because, for example, someone might have been working for you for 10 years and they haven't looked at their employment contract since they signed it on day one. So it's important to remind people of what they have signed up to do and what they must do even when they leave the company. And one last note on restrictive covenants. If you have restrictive covenants in your employment contracts, these are usually set off against any time spent on garden leave. So, for example, if you give notice to an employee and say that you now be on garden leave for 6 months, their restrictive covenants will be reduced by how long they've spent on garden leave. So, say restrictive covenant is 12 months and they spend 6 months of that time, 6 months on garden leave, the restricted covenants will be reduced down to 6 months. So which kind of works for the employee as well and makes them more inclined to follow their restrictive covenants. But yeah, so that's competition, confidentiality, and intellectual property. And I'll move on to the next slide and back to Liz.
Thank you. I forgot to mention when I was talking about redundancy, so I'm just going to go back to that point. Don't change the slide, please, Simon. But just on redundancy, that the guidance that ACAS gives is about dealing with individual redundancies. Now, if you have the possibility of making 20 or more employees redundant, so large-scale redundancies within a certain period of time, then there are collective consultation requirements which you must follow. And if you don't, then there are potential penalties. They're called protective awards that each employee that's affected can claim. So it's really important if you're dealing with large scale redundancies that you understand what your collective consultation obligations are. We're not going to be covering them in any further detail today. But yeah, just wanted to flag that, and also make sure that if you have any pregnant or pregnant employees or those on maternity leave, that you give them special consideration for alternative employment, because you have legal duties to give them preference on available alternative employment. Those are two specific points that I wanted to make, just to make sure you're aware of them, so that if you have any issues around that, you know that you need to take advice. Okay, moving on then to the slide that we're on. And Isha has touched a little bit on notice and payments in lieu of notice and garden leave when she was talking about confidentiality and restrictive covenants. So I just wanted to drill down into matters around notice and in lieu, garden leaves, and a couple of other things. So the first very important thing on notice is to check the contract. Have you got contractual notice on either side? So if your employee is resigning, are they giving the correct contractual notice? If you are terminating, dismissing them, are you giving the correct contractual notice? And is the contractual notice breaching their statutory entitlement in any way? So if they're employed for 5 years, but your contract says they get a week's notice, that's in breach of their statutory entitlement to notice. They would be entitled to 5 weeks notice because of their length of service. So check the contract. Now, the contract is also important for other things. As Isha has mentioned, you may have provisions in that contract of employment that give you the right to place them on garden leave for some or all of their notice period. I'll come into that in a moment. But you may also have the right built into the notice part of the contract to make a payment in lieu of notice. And it's important that you know about that, because if you don't have the right built into the contract to make a payment in lieu of notice, but you go ahead and do it, you are technically in breach of the employee's contractual right to notice. And that might affect other things in the contract, like restrictive covenants, because you cannot rely on your contractual rights as an employer, like restrictive covenants, if you have breached the employee's contractual rights to notice. So that's really, really important. If you've got somebody with restrictive covenants they're leaving the business, you are giving notice, you are terminating their employment, you're dismissing them, and you want to make a payment in lieu of notice, you must check that you've got the right to do that in the contract. If you haven't, do take legal advice, because it could jeopardise the restrictive covenants and their enforceability. So I'm just going to go back to the right to notice at this point. So we know that the employer or the employee can terminate on notice, and if they don't, that's a breach of the contract. And sometimes I get asked about what an employer can do if the employee doesn't give the correct amount of notice. And that's a really tough question to answer, because actually it's technically a breach of contract and the employer could sue the employee for that breach. But many times over, the employee just doesn't bother, because it's a whole heap of cost to sue them. And because it's a contractual claim, the employer has to prove loss. Well, very often the loss may only be the cost of employing somebody to infill that position. There may be lost business if it takes time to recruit somebody, but you've got to prove all of that and submit it to a court, and very often it's just easier to move on. Now, there are exceptions to this requirement for notice, and the biggest exception is if you are dismissing an employee for gross misconduct. There is no requirement to give notice, to dismiss on notice, if the employee has committed gross misconduct. We call that summary dismissal. So they would be dismissed at the date the decision is made, they would be dismissed as of that date, and that would be the last day of their employment. And even if they bring an appeal against the decision to dismiss them, that doesn't prolong their employment. They've left. The appeal can be dealt with after they've left. And if the appeal decides that the dismissal was unfair and the decision is reversed, that rarely happens, but it can happen, then the employee can be reinstated with all of their continuous employment rights intact. But when they're dismissed immediately. The other exception to the requirement for notice is on the employee's side, and that is in circumstances where they believe they've been constructively dismissed. So the employer has done something so bad that or they have breached the employee's rights in some way. Maybe it's a demotion which isn't justified. Maybe it's a change in pay, a loss of pay, a change to other contractual rights. Maybe the employee feels they've been treated so badly that there is a fundamental breach of the employment relationship. In any of those scenarios, the employee is entitled to treat themselves as constructively dismissed, and the way they do that is to resign without notice and bring the relationship to an end immediately. So that's another exception to the rules on notice. So just coming on to how payment in lieu of notice works, because often employers get a little bit confused about this. If you are making a payment in lieu of notice, whether you have the right to do that in the contract or not, that is a payment that must be taxed. It's pay, and it's referable to the contractual relationship. So you cannot make it a tax-free payment. If you elect to make a payment in lieu of notice, that means that the employment comes to an end immediately. There is no notice period, because you're deciding to pay in lieu of that notice period instead of it. So the employment ends immediately, and the employee leaves and receives a lump sum in lieu of their notice, rather than remaining in employment and being paid in the usual way, month after month or week after week, throughout the notice period. Now, garden leave is different to making a payment in lieu of notice. Again, you must check the contract carefully if you wish to use garden leave. You can either rely on a contractual right that says you can put your employee onto garden leave for their notice, or you make an agreement with the employee when the employment is coming to an end that they will go on garden leave. Either way, garden leave is fine as long as it's agreed. If it's in the contract, or if you agree with them separately. But if you don't agree with the employee, or it's not in the contract, again, any restrictive covenants that are in that contract could be jeopardised. You might not be able to enforce them before a court of law, because putting the employee onto garden leave would be a breach of contract if you don't have the right to do it. So it might mean that the restrictive covenants are not enforceable. Now, the reason I'm labouring all of this is because garden leave and restrictive covenants tend to be in contracts for relatively senior employees, people who are quite key to businesses. They may be employed at a very senior level, or they may be the brains behind a particular marketing initiative or a product or a service, and they hold all the keys to the business success. So if they leave, you would probably want to consider placing them on garden leave. You would probably also have restrictive covenants in their contract of employment to limit what they can do with their knowledge and confidential information and relationships after they've left. So getting it right contractually is really important for people like that. Less so for more junior people in a business. So that's payments in lieu and garden leave. And on garden leave, if somebody is put onto garden leave, that could be for the whole of their notice period, or it could be for part of the notice period. It doesn't have to be for all of it. So you may want them to complete a handover or finish work that they're working on before you put them on a garden leave. And that's perfectly fine, so long as you communicate clearly to them about your expectations. As Isha said, if there are restrictive covenants in their contract, usually they would be worded, if they're well drafted, they'd be worded to make it clear that any time spent on garden leave will come off the length of the restrictions. So if they're 6 months, it'd be reduced down by the amount of time spent on garden leave. If it was a month, then the restriction would be reduced down to 5 months. All of these things need to be made clear when the employment relationship is ending, so that there's no room for uncertainty. So having a letter that sets out what obligations the employee has on termination and how their notice period is going to be dealt with is really, really important. So if they're going on to garden leave, they need to understand what is expected of them, that they continue to be employed by the company and owe duties as an employee, that they have to remain available and who they're to keep in touch with, that they're not to go off and get another job because that's against the contract of employment. So very, very important to have a letter setting out that expectation. And similarly, on ending of employment, employees have rights to be paid any outstanding holiday pay, and that is sometimes forgotten. So statutory holiday entitlement has to be used during the holiday year while people are employed, but if they leave, any accrued statutory entitlement for that holiday year must be paid if it's not used on termination. And you can require your employees to use their holiday during their notice period so that you don't have to pay it when they leave. But if any is left over, it has to be in their final pay. You need to make that clear in the letter that you send to them. And so I'm going to deal finally with settlement agreements. When and how to use. So settlement agreements are one of the ways in which you can end an employment relationship, but they're not the only way. They're significant because they are, apart from a COT3 ACAS agreement, they are the only way in which you can agree with a leaving employee that they will waive their employment claims against you as their employer. They're the only way that employment claims can be waived, unless there is involvement with ACAS and ACAS agree to put together what's called a COT3 agreement. But I'm leaving COT3 agreements to one side. They're quite specific. Settlement agreements then can be used, and they tend to be used in situations where either there is a workplace conflict and you cannot agree how to end the relationship, the employer won't resign, you don't really want to go ahead and dismiss, there may be risks around the legality of the dismissal, the process or the reason, the evidence, the facts, and you want to buy off that risk. You want to make sure that risk doesn't continue. and the employee doesn't go on and bring a claim. So you would have to negotiate with the employee, have discussions with them around trying to agree a mutual termination of employment. So often I advise on settlement agreements in that scenario. They can also be used where there may be a redundancy, a perfectly legitimate redundancy situation. Employer has consulted and done all the right process. There's nothing unfair about it, but the employer may decide to pay an enhanced redundancy payment if the employee signs a settlement agreement. And I advise on many settlement agreements in that scenario too. And then the third scenario where settlement agreements tend to be used is where the employee has already begun a claim, where they've left employment, or they may still be in employment to be claiming discrimination, for example, and the parties want to settle the specific claim that the employee is making to the tribunal. So those are three different scenarios typically when you would use a settlement agreement. And the how is a little bit more complicated. So if an employee is still in employment and there's no legal claim been brought against the company, but the employer just wants to bring things to an end. Maybe there's a performance issue, a concern that needs to be addressed, and it hasn't been, and the employer really doesn't want to have to go through the hoops of dealing with underperformance, performance improvement, warnings, and then dismissal. Or maybe there is a misfit. The employee isn't really getting on well. They're causing difficulties. There might be some misconduct involved. So in those scenarios where the employer hasn't taken any steps to address the issue, or they may have started to take steps, but things are getting messy and they just think there's a lot of risk involved with going ahead to dismissal, then often the employer might start to think about using a settlement agreement. And in that scenario, it's really important that the employer is aware of what they can and can't do in having discussions with the employee. There is some law which allows either party, the employer or the employee, to start discussions about ending employment. And that law says that those discussions can be kept confidential and can be protected. In other words, they don't feature then in any employment litigation that follows if there isn't an agreement reached. So that protected conversation law is very specific. It allows the parties to come together, but it must be handled with care. It must be done in a way that isn't intimidating, doesn't put the employee under duress, pressure, doesn't say do this or resign. So it's not an ultimatum. So the way in which it's badged, the way in which it is handled is very important. And if it's not done correctly, an employee might say, well, that wasn't a protected conversation. I've been put under pressure. I'm going to refer to this in a subsequent claim. And I have seen that happen. And if that does happen, then things can get very messy in front of the employment tribunal. There has to be evidence about what was said, how it was said. So you don't want any of that. You want to keep it clean. You want to know that you can rely on that conversation, and that conversation will lead to an enforceable settlement agreement. So my strong recommendation is take legal advice if you are preparing to have a protected conversation. Don't try and do it yourself and then get it wrong. There is a process that can be used very effectively, but you need to get that process right. So that's all I have to say on those issues. I'm going to move on to think of the thorny issues for a few moments. I've talked about constructive dismissal already, and what I want to say about it now is that if you have a scenario where an employee resigns in what I call the heat of the moment, puts a letter in or fires off an email and says, I'm done, I've had enough, this happened and I can't work anymore. So that's what I call a heat of the moment resignation. It's not considered, it's taken in the heat of the moment. You are at risk of a claim for constructive dismissal if they have 2 years or more service, and there are steps that you can take to try and reduce that risk. So having some communication with that employee about why they've taken that decision. Giving them a cooling off period, asking them if they want to reconsider would be really important evidence before an employment tribunal if they bring a claim subsequently. In other scenarios where constructive dismissal is claimed, there might be a grievance that escalates and they're very unhappy. That might be a situation in which to think about using a settlement agreement, because there could be quite a hefty risk of a constructive dismissal claim if they resign. The important thing about constructive dismissal is that the risk is on the employee with the claim, because they have to bring the claim to the tribunal and say, I wasn't dismissed, but the circumstances mean that I was dismissed. So my employer didn't issue me with a letter saying you're dismissed, but I claim that their actions were a dismissal. And that's on the employee to prove. It's all on them. Nevertheless, if they do bring that claim, it does mean you've got to defend it, and there are costs and aggravation involved in all of that. Removal of directors is a point to mention if a director is leaving employment. And the important point here is that their directorship is not the same as their employment. So a director is an officer of a limited company. There may be a named Companies House director. They have specific statutory directorship, or there may be in name only director. So I'm thinking about directors who are named on Companies House. They're statutory directors. They're officers of the company, and their position as a director is not the same as their position as an employee. It's usual for directors, particularly Companies House directors, to have service agreements that make it clear that if their employment ends, then their directorship will automatically come to an end, and they will cooperate to effect that resignation as a director. If those things aren't in the service agreement, then it will be down to the company's articles of association and what's in there about removing them as a director. You don't want the hassle of that. You want their employment and the directorship to be linked together, so that if employment ends, the directorship comes to an end, and vice versa. A word about references. So there is no legal obligation for any employer to give a reference to an employee who's left, or to an employer who wants to employ them in the future. But if you decide to give a reference, then legal duties kick in. And there is a legal duty to make sure that the reference given is accurate and fair, and that it does not mislead the future employer. Now, it's for that reason, and a lot of litigation about references that have been given in the past, large awards of damages given to either the employer who relied on a misleading reference, or the employee who felt they were treated unfairly because of that reference. It's because of those litigation cases that more often than not these days employment references are extremely basic. They usually confirm facts and no opinions, because giving an opinion is dangerous. It could be taken to be unfair. It could have information that is misleading to the future employer. So employers have withdrawn from giving opinion-based references. They tend to only confirm the dates of employment, the role that the employee was in, and possibly a brief description of their job. And really, there's very little else there. In the financial sector and in education, I appreciate that references can be much more complicated than that. But in the corporate business world, apart from regulated sectors, they tend to be fact only. Now, if you want to agree a specific form of reference with the employee, that's perfectly fine, as long as you make sure that it doesn't mislead the future employer who's relying on it. You can agree a specific wording of references in settlement agreements. But again, if you do that, you need to make sure that whoever is approached for a reference within your business knows about the agreed wording, so that they don't give a different form of wording that then would breach the settlement agreement. So those are my thoughts on references for now. We could say a lot more. We have talked at some length about restrictive covenants already. What I just want to say here is employee leaves, they've got restrictive covenants. You've reminded them of their restrictive covenants in their leaving letter. They know what's in their contract, but then you find out that they have breached a covenant. They've approached one of your key clients, your key customers, and they say, come and work for me, and that's within their restricted period, what do you do? In short, you've got to remind them about the restrictive covenants and tell them that information has come to light that's suggesting they may have breached or be preparing to breach them, and you need to warn them of the consequences they would face if they do that. You don't go straight to a court of law, because doing that would be premature, but you do need to take steps to protect the business if that person goes ahead with what they've threatened to do, or if you know that they've done it already, you might have to go straight to law and straight to a court of law, and you may have to apply for an injunction. But those are very expensive forms of litigation, and you wouldn't be doing that without legal advice and legal representation. And you'd probably only consider an injunction in the most serious case where there's a lot of commercial damage done by somebody's behaviour, somebody's breach of contract. So take legal advice. And that is all I need to say on those matters. So if you have any questions you'd like to put to me or Isha, now's your chance. Happy for you to put questions in the chat if you don't want to come off mute, and we'll take any questions through the chat. We'll give you a couple of minutes, but if you don't have any questions, we'd like to thank you for watching, and I'll hand over to Isha to bring things to a close.
Yes, so as Liz said, if you've got any questions, feel free to pop them in the chat. And whilst you're thinking and you're potentially typing, just like to let you know that we've got a HR promotion on at the moment, which will be running for the remainder of Feb and until the 31st of March. And our promotion is for £950 plus VAT. Then we will be reviewing up to 2 templates contracts that you have in place, and basically reviewing them, highlighting areas of concern. And if we feel that a new contract is appropriate, we will provide a template for you, and we'll also note down any fees and quotes about work that we could do to improve it if a new contract is not appropriate. And we'll also be reviewing up to 15 of your HR policies, again letting you know what's missing, letting you know if everything is up to date, and providing any information about changes that you need and how we can work with you to implement those. So that is on until the 31st of March. And if you're interested or know anyone who would be interested, then please let me know. My email address is on the screen, and I have also been the one emailing you about the webinars, so you'll have it in your inbox somewhere. So it looks like there are no questions, so I think we will stop the recording there and just thank you again for joining. As I said earlier, we'll be doing a shorter series